the prenup season is on. Jeff Bezos got married and Lauren Sanchez. I almost have every week a prenup to prepare. And one might wonder, what does ultra wealthy prenup entail? Someone with 9-figure net worth, what would they include in a prenup? Well, first of all, they would include an NDA, meaning a clause, non-disclosure clause, to say that the fact that this prenup exists cannot be disclosed. So, for example, I could imagine that Lauren Sanchez signed that type of clause. If someone asked her that question, she wouldn't be able to disclose it. Another thing that prenup would entail is who gets to access private jet, who gets to speak on or post on social media in case of divorce. Just keep in mind, the prenup is an agreement that is typically enforced at the time of divorce. It's not an agreement to micromanage the marriage. So, for example, things like who would do on a regular basis what is not very typical for a prenup. It would define what assets to divide, especially that are not easily sellable. For example, private equity shares, startup equity shares, intellectual property, things like that would absolutely require some definition and buyout clause or segregation clause that it remains a separate property of the person who owns this right, owns this equity. Otherwise, it creates a lot of litigation opportunity, which the whole point of the prenup is to prevent. Homes. Sometimes, most of the time, with someone with 9-figure net worth, they have homes everywhere. New York, London, California, Florida, and divorce can be filed anywhere. They include choice of law clause, which means the prenup would say that in case of a divorce in a different state, that judge in that state has to follow California law. It becomes tricky if the prenup is signed, for example, in Germany under German law or French law. I just had a case where if the prenup is signed in another country and that country doesn't have certain rules, for example, financial disclosure, then the big question is, would that prenup be enforceable in California? And what I would like to see in these type of prenups, that it says yes, and California or any state or country has to follow French law. Because in France or in Germany, it would be enforceable. So then we would fly in experts from countries where the prenup was signed to testify in California about the validity of the prenup, and then consequently it would be enforced in California under the other country law. So I would keep in mind when someone gets married to get consultation from different states and countries where the property real estate is located to make sure that there is no cross-reference problems to enforce the prenup. Potentially even have 2 prenups. So if I know they have 2 properties, England and let's say in California, and then sometimes it's wiser to have a prenup created in England, same type of provision, following the rules in England, and then matching prenuptial agreement in California, instead of then enforcing and flying in experts from a different country to California. I created this book to help you understand the divorce process without getting lost or without getting a heart attack. You can buy it on Amazon in all formats, including audio format. Homes. Speaking of homes. So the prenup can define who needs to move out when. Let's say 30 days after divorce petition has been filed. The non-owning spouse has to move out, or ex-spouse has to move out. Who is going to be supervising the packing? If we're talking about a lot of estates, obviously the prenup would say which home remains with which spouse, and then who is going to be supervising the packing. Now, behavioral clauses are less likely to be enforced specifically in California. Behavioral clauses would be, for example, if another spouse cheats, then he or she has to pay $1 million. California law is a no-fault state, which means you don't have a you don't have to be at fault in order to file for divorce, and such clause would be considered against public policy. And if that clause specifically is not enforceable, it does not mean that the prenup is not going to be enforceable. Okay, let me clarify. If one clause is not valid, the prenup stands. The whole prenup stands, because all prenups have and should have a clause that's called severability clause that says if one provision is not enforceable, the whole prenup should stand. Child support, child custody is a topic that judges don't enforce, because typically in a prenup, either there is no child, or if there is a child, it's not part of the prenup. The prenup is binding agreement between two spouses, and custody is typically defined in different types of agreement, custody and parenting agreements. Sometimes a prenup could have a sunset clause. A sunset clause could say that the prenup would expire after 5 years of marriage, after 10 years of marriage, when in California, 10 years considered long-term marriage, which is a different topic for long-term spousal support. However, it's very typical to have some sort of limitation on payment. For example, 5 years of marriage would mean $5 million, 10 years, 10 million, and of course, prorated depending on the length of the marriage, and cap it at 20 million. Now, how would prenup look like in California to be enforceable? And there are certain rules that the prenup and the surrounding circumstances would have to follow. Number one, full financial disclosure. Every prenup, in order to be enforceable, as a matter of law, Code Section 1615 Family Code, has to have the full financial picture. So the spouse on the other side would need to understand what they're conceding, what they're waiving, what they're negotiating. So all cards have to be on the table in order to have a fair prenup. Otherwise, if it's not there, there is not even a requirement for trial. The court could set it aside as a matter of law, potentially in the first short cause hearing in a summary judgment. Next, representation. Although it doesn't specifically say that each party needs to be represented, the way it's phrased in the Code Section 1615, that it makes it absolutely necessary, especially high net worth prenups, to have representation, because it says, and I'm going to paraphrase it, it says, if the spouse who is on the other side, less privileged spouse, is not represented, let's say reviewing spouse of the prenup, then that spouse needs to receive a memorandum of understanding about what they're signing. So basically, it would require the drafting attorney to send a memorandum of understanding plus a waiver for attorneys as in a separate writing to say, well, you have been advised to seek an independent counsel and you decided to waive. And I personally wouldn't touch a prenup if I knew that the other side is not going to be represented. And it never happens in a high net worth case. Of course, you want to have a reviewing attorney on the other side. It makes the prenup more enforceable. 7-day rule. What is that? So 1615, same code section, states, paraphrasing, that the final version of the prenup, and final means negotiated, concluded, everything is ready to go, fine, typos is not a significant change. So no significant changes to the prenup can be made. And then you wait 7 days before signing. So again, so the prenup has to be finalized, 7-day, let's call it cooling off, and then signing. And the signing has to be before the wedding. It can be on the date of wedding, but at least 7 full calendar days. The longer, the better. Then there is this catch-it-all phrase in 1615 that states the judge could set aside a whole prenup if at the time of enforcement the court finds it unfair, unconscionable. The high net worth spouse would be encouraged, I would encourage that client to make the prenup as fair as possible at the time when it's drafted, so that it's not going to be set aside at the time of enforcement. So it's a good idea to offer money, and typically that's not the goal in 9-figure type of prenups, to make the other spouse walk away with nothing. Typical goal is to preserve wealth, preserve control over companies, and have the other spouse be well off without destroying the spouse who built it at the same time. So it's a balancing test. Another thing to consider in the prenup with spousal support waiver, I would not recommend a spousal support waiver. I would recommend shorten it, specify the amount, specify the length, but not waive it. Because a lot of California cases of appeals have been very critical and sometimes set aside the spousal support waivers because, again, at the time of enforcement, it was seen as not unconscionable, meaning unfair. And of course, a final thought, child support, child custody is off limits, so it's not part of the prenup. Hope that was helpful. I will see you in my next video. Bye.